Good evening, everyone. A warm welcome to this important and insightful webinar on understanding data protection laws, a legal perspective. This webinar is brought to you by Naksh Foundation under its flagship initiative, Project CyberShield, as part of Cyber Awareness Week. Cyber Awareness Week is a week long mission all about making the digital world a safer place for everyone. It is an age wherein cyber threats lurk around every corner and awareness is our greatest defense. Through this campaign, we are here to educate, empower, and equip you with the knowledge to navigate the internet safely. I'm Akanksha Srivastava, and along with my co host Simran, it is our honor to be your host for tonight. Now, data protection laws are very essential legal instruments that govern the collection, storage, processing, and sharing of personal data to ensure the privacy and security of individuals. These laws aim to prevent misuse of data, unauthorized accesses, and breaches, thereby upholding the fundamental right to privacy. From a legal perspective, data protection involves balancing individual rights with the legitimate need of businesses, governments, and other entities to use data for specified purposes. And key principles include consent, transparency, data minimization, purpose limitation, and accountability. Laws like the European Union's General Data Protection Regulation (GDPR) have set global benchmarks by emphasizing user control and imposing strict compliance requirements. In India, the Digital Personal Data Protection Act 2023 lays down obligations for data fiduciaries. and rights for individuals, such as the right to access, correct, and erase personal data. Judicial interpretations, especially by constitutional courts, play a pivotal role in shaping the application and enforcement of data protection norms. As digital technologies evolve, legal frameworks must adapt to address emerging challenges and uphold data sovereignty. To discuss this topic in more details, we have a very distinguished guest with us today, Advocate Abhishek Singh Sir. Now, before handing over the session to Abhishek Sir, all participants are requested to take a note of a few basic instructions. This session is being streamed live on YouTube, and for those who are unable to join via Google Meet, you can easily participate by following the YouTube link provided. Before we begin, participants, we request you to keep your microphones on mute throughout the session to avoid any background noise. Keep your video turned off unless you are in a proper setting. And if you have any questions or queries, please drop them in the chat box. We will address them during the Q&A session at the end. And participants, kindly note that it is mandatory for you all to fill the feedback form, which will be available 10 minutes before the end of the session, in order to be eligible for the certificate of participation. Thank you for your cooperation. And without further ado, let's invite a guest speaker for today's session, Advocate Abhishek Singh Sir. Sir is a distinguished legal and policy professional working as an associate at Lakshmi Kumran and Sridharan Attorneys, TMT, and Data Protection Team. An alumnus of the 2017-2022 batch, he was a founding executive member of the first of its kind Center of Excellence for Cyber Law at his alma mater, Institute of Professional Studies, WIPS, IB University. Certified as a Data Security Council of India privacy professional, he excels in data protection, privacy, and AI frameworks. Sir has contributed significantly to policy paradigm with three report publications on the United Nations website representing India in regard to human rights initiatives. He has also worked with Cyber Peace Foundation as a research associate and policy team lead, focusing on numerous techno-legal and policy-based projects and campaigns with ministries and government institutions including MOD, MHA, NCPCR, NCB, NCRB, MHA, MEA, etc. He has also led and provided inputs in public constitutions for the Digital Personal Data Protection Act 2023 and other cyber laws and policies such as the IT Rules 2021. He is also an awardee of the Chief of Army Staff Commendation Card in 2024 for his professional contributions towards the Indian Army. Currently, Sir assists a diverse global clientele on compliance, advisory, regulatory, and policy related matters concerning data protection and other prevalent cyber laws at LKS. Without further ado, I would like to hand over the floor to Sir for his insights on the topic. Over to you, Sir.
Thank you so much, Akansha. I hope I'm audible.
Yes, Sir.
Thank you so much. So, firstly, at the outset, I'm very thankful for to the Naksh Foundation for giving me this opportunity to actually interact with you guys and spread awareness about the data protection paradigm in India. So, first of all, I would request everyone to keep this session as interactive as possible because even for me, it gets a little boring to speaking to a screen after a certain time without seeing anybody's faces around. So, as we keep going and booming ahead with the technology, we do forget sometimes the basic essentials of when we talk about data protection and cybersecurity. So let me just start this with a couple of questions before I jump onto my presentation. And if anybody wants to answer, please feel free to answer on this. Uh, how many of us actually have read or even glanced through privacy policy of Instagram or Facebook if you use that in present time? Just a show of hands. Okay, I have one few. So out of 80, I say the number is somewhere around 4 to 5 people who are raising their hand right now. Now, coming to the basic problem at hand in this case. when we talk about data protection is something which makes us all responsible for our own data. Now, let me just put it into a very simple perspective. Right now, we're all scared that cyber crimes are on a all-time rise. You have all these automated messages coming your way, which talks about not sharing your OTP or your bank credentials or any of the personal data with anybody. So let me just tell you, this is nothing new. It's not that this is happening for the first time, or these kind of scams or frauds have been going on for the first time. This has been happening since the 70s, since the 60s, wherein you would actually receive a telegram or a letter at your home which would say that you have won a lottery or you have some banking thing, and please go and get this resolved. To which correspondingly, after 2 days, somebody will reach out to you at your home and try to lure you into the trap. So the frauds are mostly the same. It is just that the medium in today's time has changed into a digital medium. So without wasting any time, I would like to just start on with my presentation. Uh, if you could confirm if my screen is present.
Yes, sir, it is visible.
Oh, perfect. So now, when we talk about the understanding the data protection laws, so we got to understand one thing, that it is not a new thing which has come out our way in terms of data protection, because lately people have seen this a lot in terms of discussions in policy groups and even in the legal sphere, that data protection is of utmost importance and we need to take care of it. But this is not something which has just evolved or just popped up. This has been there since the early 2000s, when the IT Act, the Information Technology Act, came into existence. And the first concrete legislation which came in for data protection came in 2011. So, just to give you a fair idea and a fair perspective on what the evolution of the DPDP Act looks like, is this. So, in 2017, we had the landmark judgment of Puttaswamy versus Union of India, which subsequently resulted into the formation of the Justice Sri Krishna Committee, which submitted its report on the PDP bill in 2018. In December 2016, the PDP bill, that was the personal data bill, the personal data bill, was tabled in the parliament. To constitute the policy effects of it, the Joint Parliamentary Committee was set up in 2021, which actually led to the withdrawal of the PDP bill, which was tabled in 2019. In 2022, November, the Digital Personal Data Protection Bill was released for public consultation. And in August 2023, the bill turned into an act and was introduced into the parliament and was subsequently passed in both the houses and received the parliamentary assent. So, if you just carefully and broadly just see the timeline, we will see that the original bill, which started off in the form of PDP, which is Personal Data Protection Bill, and ultimately accumulated into a digital personal data protection bill. So, if you see with time, the legislation and the policy makers have been cognizant enough and mindful enough to understand the implications of what is required in the society. Hence, from personal data protection, it came to digital personal data protection, because the data in the digital sphere is also equally important to be protected. Currently, the information technology reasonable security practices and procedures and sensitive personal data or information rules, or as we call them, the SPDI rules of 2011, under the which were notified under the section 43A of the IT Act, are presently applicable on all body corporates, that is the companies and individuals in the country. Now, when we talk about the fundamentals of the act, so, in a nutshell overview, the Act has a total of 9 chapters and 44 sections, and various provisions of the Act shall come into force on different dates. And also, just to bring everyone on this clarity and to bring everyone up to speed, the DPDPA, that is the Digital Personal Data Protection Act of 2023, has not yet been implemented. The act has been notified and has received the parliamentary and the presidential assent, but is yet to be implemented. So, as till this time the DPDP is not implemented, the provisions of SPDA rules will be effectively in force. Now, the digital personal data. What exactly do we understand by digital personal data? So, digital personal data can be any data which belongs to you, that is the personal data, which is either in digital form or collected or obtained in a non-digital form and then subsequently digitized. So if I am collecting your name or your email ID and your phone number in a register, which I'm then subsequently digitizing onto an Excel sheet or onto another digitized format, then it will be under the purview of the act. Now, the purpose the purpose of the act is to provide the paradigm for processing of digital personal data in a manner that recognizes the rights of an individual and also ensures that the processing which is undergoing is undertaken under a lawful basis. Now, in the bird's eye view, this is how the act looks like. This is the shape of the act. So we have 9 chapters, starting from the preliminary chapter where we have the title, definition, and the applications. Then the second part is the obligations of data fiduciary, which is essentially the most important part for in from the perspective of compliance by companies, as most of the companies will either be data fiduciaries or data processors. So accordingly, the obligations will follow. Then we have the rights and duties, the special provisions, then the establishment of the regulatory authority, which the regulatory authority, which is actually the Data Protection Board of India. Further, we have the. Can somebody confirm if my screen is still visible?
Yes, sir. Now it is not visible.
It's not visible. Okay, I'm so sorry. Just give me a second.
Absolutely, sir.
Is it better now?
Yes, sir.
Okay, perfect. So sorry about that. But I always say, what is a virtual meeting without technical glitches? How will we ever enjoy it? So yeah, coming back to the regulatory part of it, the Data Protection Board of India, which will essentially be the supervisory / the regulatory authority, which is going to govern the aspects of data protection. Then we will talk about the powers, functions, and the procedures, the appellate dispute mechanism, the penalties, adjudication, and the miscellaneous parts of the act. So, moving ahead with the key definitions. So, the data processing ecosystem in India comprises, under the DPDP rather, would comprise of three major players. Number one would be the data principal. The data principal is essentially the individual to whom the personal data relates or can be identified by such data. So, and also in case of a child or a person with disabilities, the parents or the lawful guardians of such an individual will be deemed to be the data principal. Now, when we talk about who is essentially the data principal in this case, so anytime you are giving a data which can be used to identify you, so whether it can be your name, it can be your address, it can be your email ID, it can be your phone number, which essentially either in isolation or if put together in conjugation with other additional data allows anyone to identify or pinpoint onto you, then that data shall classify as your personal data. Now, the second entity herein would be the data fiduciary. So, a data fiduciary is essentially any entity who, alone or in conjugation with others, determines the purpose and the means of processing of personal data. Now, what do we exactly understand by purpose and means of processing personal data? For example, if we have Amazon is collecting your name, your email address, your mobile number, your home address to provide you a certain functionality that is allowing you to browse through a lot of products on the platform and subsequently place an order which is being delivered at your home. So, whatever data is being given to Amazon on the app, Amazon as an entity is determining the purpose and means of why and how that data will be processed. So, that is what a data fiduciary does. Data processors are the third entity in the ecosystem. That is any person who processes personal data on behalf or on the strict instructions of fiduciary. So what we see here is that a data processor essentially has no uh, control over the scope, means, and purpose of processing. So processing is being undertaken by the data processor purely under the instructions of the data fiduciary. And one major obligation under the Act says that all processors should be appointed contractually. There cannot be any processor who has been appointed beyond the constitutes of a contractual relationship. So, for anybody who will be working in this space as a fiduciary or as a processor, please ensure that there is a contractual relationship between the two so that there is no problem in terms of deciding the liabilities when it comes to the compliance landscape. Now, again, coming back to what is personal data. So, any data about an individual who's identifiable by the data is essentially your personal data. So herein I've added a couple of things which may amount to personal data either in isolation or in when read in conjugation with others. So all these things will amount to personal data. So please be mindful whenever you're entering a form or whenever you're providing your data to any of the fiduciaries. Please ensure that if you are providing this kind of data, then it will be covered under the DPDPA. Now, when we talk about the scope of DPDPA, how the act shall be implementable or enforceable on the entity. So, processing is something which gives out the result to it, gives out the result of why we have provided the personal data. So now when we talk about data, so data is essentially a representation of informations, facts, concepts, opinions, or instructions in a manner suitable for communication, interpretation, or processing by human beings or by automated means. So it covers the wide array of what essentially a data would encompass. So could be a fact, could be an opinion, could be a post, could be a video, could be a part of the video wherein the aspects of information, facts, concepts, opinion, and or instructions are in a suitable manner for communication, interpretation, or processing. Now, and of course, we are very clear on personal data. So when we talk about the scope of DPDP, I've tried to just clarify that or make it a little bit more clear with the flowchart. So if you have data, the data can be divided only into two parts. The number one is personal data, and the second is the non-personal data. So the applicability will trigger in terms of personal data, and personal data when used for personal or domestic purposes or is made publicly available under any other law shall not be covered. So any personal data other than these two will be covered under the act, and hence the fiduciaries will have to undertake the obligations as specified as we'll go through ahead. Now, the applicability of the DPDPA, this flowchart is essentially pinpointing and showcasing as to how the act and in what kind of scenarios the act will be applicable. So let's start. If we say that the data is digital personal data, then the act will be applicable if the processing is taking place in India. If the processing is not taking place in India, the act will not be applicable. However, when processing is being conducted outside India for offering of goods and services to data principal in India, then the provisions of the act will be applicable on the respective fiduciary slash processor. Now, in this regard, if you see, it is very important that earlier it has been seen as a trend that entities who do not have offices in India or do not have representations in India are often seen to seek exemptions under the applicable law, stating that we do not have offices here. and we are based out in some place else, maybe in the US or maybe in the Europe, and hence they try to avoid the applicability of the Indian laws. However, this is not the case under the DPDPA. So even if an entity is located outside India and is offering services in India, they will very well be regulated under this act. Now, what exactly I've been stressing a lot upon the word processing. So, what exactly processing is? So, processing is in relation to personal data. It means a wholly or partly automated operation or set of operations performed on a digital personal data. Now, when we say a set of operations, what we see in terms of collection, recording, organization, structuring, alteration, transportation restrictions, and all the other facets which have been presented on the slide will amount to processing, even in combination or in isolation. So, it is very important and critical here to point out, if you see, collection in itself will also amount to processing. So if there is any entity which is just collecting the data and not even say structuring it or storing it or transmitting it, even the mere collection of data shall amount to processing. And the moment you decide the means and scope of processing, the entity becomes a data fiduciary, hence triggering the applicability of the act in day-to-day functionality and operationality of the entity. Now, as I pointed out earlier, the data principles also include children and person with disabilities. And to that regard, the data principle would be the lawful parents or the lawful guardian of that individual. So, in regard to the processing of personal data of a child or a person with disabilities, a verifiable parental consent has to be obtained from the lawful guardian. Additionally, no processing can be undertaken that is likely to cause a detrimental effect on the well-being of a child, and no processing in regard to tracking or behavioral monitoring of a child or even the targeted advertisements shall be permitted. The exemptions for such will be prescribed by the government under the DPDP rules, which have just been the consultation period for the DPDP rules just ended last month, and we're hoping that the government will soon notify the rules to ensure the implementation of the act. So more clarity on as to how and what kind of entities will be exempted in regard to the processing of personal data for children and person with disabilities will get clear with the rules. However, it is a fundamental rule that everyone should be aware of, that while collecting or processing the personal data of a child, please ensure to collect a verifiable parental consent from the lawful guardian of that person. Now, it is very important for us to understand one thing in the digital age in present time, that we are often providing personal data to entities to allow them to offer us some functionality. It could be as diverse as having a account on Facebook, which allows you to post, interact with people, search for things, or even for very simple basics of booking your movie tickets or booking shows. It is very important for an individual or a data principal to ask the question before providing any personal data, that is this processing even lawful? Because whatever I mentioned as part of the definition of processing is something which even a scammer is also undertaking, essentially: collection, organization, structuring, transmission of information, right? So all it is very important that a lawful basis always exists whenever processing is being undertaken. So when we undertake processing, the lawful basis under the act are two. Number one is something to which the data principal has provided consent, and so the other is the legitimate uses. Now, legitimate uses have been specifically called out under the act, which will include processing by the state for providing subsidies or licenses under the state instrumentalities and such. So always ensure whenever providing data, or even if going through a privacy policy, to understand and to pinpoint as to what is the lawful basis of the processing which is being undertaken. Now, coming to the essentials of the act, as a data fiduciary, it is important, or even as a data principal, it is important to know what the essential ingredients of the act are in terms of the compliance. So, starting with the first and the foremost important is notice. So, notice is something which is provided to a data principal prior to the collection of personal data, and this notice becomes the basis for a fiduciary to collect an informed consent from the data principal. So, a notice, as you can see, a consent should be free, specific, informed, unconditional, unambiguous, with a clear affirmative action, and signifies an agreement to process data. So, a notice, the consent obtained from the data principal should fulfill all of these requisites, as it cannot have any undue influence, it cannot have any ambiguous terms and conditions along with it, you cannot have hidden terms and conditions with it, and it cannot be on the basis of something which you have denied. So the free, specific, informed, unconditional, unambiguous, clear affirmative action are very important aspects of consent. And wherever, as a data principal, you feel that these aspects of your consent are not being fulfilled, please refrain from providing a consent, or rather engage with the fiduciary who's seeking your consent on more details as to what is the processing in regard to. Now, the notice essentially will encompass the following. So, the personal data collected and the specific purpose of collection, the processing activities associated with the personal data which is being collected, the mechanism to withdraw consent, the mechanism to exercise data protection rights, and the mechanism for grievance redressal and appeal to the Data Protection Board of India. Now, it is very important to see that on the starting of the slide, we're talking about the very ingredients of a consent. And the third point says mechanism to withdraw consent. So, just to create a bridge over here, the aspect of unconditional and unambiguous consent can be seen in this as a consent which has been provided to the data fiduciary should be allowed to be withdrawn by the data principal with the similar ease by which it was provided. So you have the option of providing your consent, denying your consent, and even withdrawing your consent in regard to the processing of your personal data. Now, it is very important for you to understand, because sometimes we go onto websites or we go onto apps wherein we have no option but to give our personal data to allow the app or the website to provide us with that particular functionality or operationality. So please be mindful about the aspect of what is being covered into a notice. And a notice is essentially a concise version of the privacy policy. So where the you may even if you're not a law student, or even if you're not aware of the legal jargon, the notice in itself has to be made in such a simple language that you understand what the processing is all about. Essentially, to improve the accessibility and awareness about these things, the law also mandates the data fiduciaries to present the notice in 22 Indian regional languages apart from English. So, for somebody who is not very literate, or is not really fluent in English, or is not even has not even read English, has the option of even reading that notice in their own regional language. These 22 regional languages are the ones which have been specified in the Schedule 8 of the Constitution of India. Also, one important clarification is that if a consent has been obtained before the commencement of the act for any of the by any of the fiduciaries, once the implementation comes into force, all these such data fiduciaries will have to seek and obtain a fresh consent. So ensure that whenever the act is implemented, the data, the apps, the websites where you are providing your data or have provided your data, please make sure that they obtain a new and a fresh consent from you. And in case they don't, please exercise your right to delete the data. Now, again, coming to the main aspects of consent, which we discussed also in the previous slide. So, when we talk about the clear, affirmative, and unambiguous part, we essentially talk about the individual giving a consent by a clear and affirmative action. So, your silenced or your pre ticked boxes or inactivity will not amount to consent. Oftentimes we see websites wherein there are boxes which are already ticked that you allow for to share your data for communication or marketing purposes and such. So that is not allowed. You will actively give your consent by ticking a box and not just going ahead with the pre-tick box. Now, when we talk about the informed aspect would include the fiduciary's identity, the purpose of processing, and the possibility to withdraw consent. The specific nature of consent, that the consent cannot be hidden in the privacy policy or under the terms and conditions, covers all processing activities for the specified purposes. For every new purpose, fresh consent should be obtained, and no bundling of consent shall be allowed. So, if I am providing a consent for one specific form of processing, it cannot be assumed or deemed that I have provided consent for all forms of processing. Every time a new form of processing comes into light, a fresh consent will have to be sought. Now, when we talk about freely given, consent must be genuine and free, with individuals having the option to refuse or withdraw consent at any time without any detriment to the processing activities. Consent will not be valid when there is a clear imbalance between the individual and the fiduciary, and under the presumption that the consent was not given freely. The individual is not allowed to give separate consent for different processing activities, as I mentioned, which is corresponding to the scope of the bundling of consent as well. Now, the withdrawal of consent is equal, and I would say is equally important when it comes to the scope of providing a consent. So, a withdrawal of consent, the data principal has the right to withdraw consent at any time. The ease of such withdrawal should be similar to the ease with which such consent was given. And upon withdrawal of the consent, the data processors also, that is the contractually appointed data processors, also need to cease the processing of the data at the earliest. Non-compliance by a data processor will be considered non-compliance by the data fiduciary, as the act does not place any direct obligations on a data processor. I would request everyone to please take the statement into consideration and ponder upon it as we go through the next set of slides, and still ask this question again at the end of the presentation: if you agree with this aspect of non-compliance by processors being non being the non-compliance by data fiduciaries. Now, one very interesting aspect of the DPDPA, which sets us apart from the other global data protection legislations, is the consent manager. So, consent manager is essentially a person who will be registered with the Data Protection Board of India and shall act as a single point of contact to enable a data principal to give, manage, review, and withdraw their consent through an accessible, transparent, and interoperable platform. Consent manager shall be accountable to the data principal and must act on the behalf of data principal in such manners and subject to obligations as may be prescribed. So I'm sure a lot of people right now might be a little confused seeing the very heavy jargon coming out of this slide. So just if anybody here is aware of any form of consent manager or anything similar you ever come across. Okay, I think in spirit of time, because we'll not have the option of hearing anyone, let me just clarify this for you very simply. So when it is something new, it does not mean that it is bad, right? So there's nothing to be scared about or worried about what a consent manager will be or how will they do it. So if you just go through the definition once again, a person acting as a single point of contact to enable data principal to give, manage, review, and withdraw their consent through an accessible, transparent, and interoperable platform. Now, if you put this definition analogous to a very simple instance, which I think a lot of us come across every day. So, irrespective of you, if you're a iOS user, or if you're an Android user, just go back to the moment when you go onto a new website, a fresh new website which you've not visited before, or you go to a new app which has not been downloaded. The moment you go onto the sign up functionality, automatically, the moment you click there, three options appear. One is login with your email, second is login with your Google ID, and third is login with your Apple ID. Now, the moment we click on Google, login with Google, or say login with Apple, aren't we essentially allowing an entity to provide consent through an accessible, transparent, and interoperable platform? Additionally, when such information has been used by, say, by Google or by Apple to log on to a website, you always have the option of going back to your Google Manager slash your iOS settings to withdraw or manage that, or review that consent. So a consent manager is something which is already existing in the ecosystem, which we use on a daily basis also. It is not that it is something new, but it is just important to be aware and be mindful as to what essentially are the responsibilities and role of a consent manager. Now, I mentioned about the certain legitimate uses under the DPDPA in regard to the legal basis. So, the legitimate uses include personal data provided by the data principal voluntarily. So, this will be the personal data which you have provided to a data fiduciary voluntarily in a manner to in which you have not denied consent. So, for example, if you go to say, let's take a very elementary example of if we go to a shop, a kirana wala, where the generation of the bill will be through a when you provide them your mobile number, or when if you provide them your name. So the moment you go there and you give them your mobile number or your name for the generation of the receipt or for the bill, you have voluntarily provided your personal data to which you have not denied consent, because if that consent would have been sought, you would have given that consent. So in ease of that operationality, these kind of processing activities are under the certain legitimate uses for the purpose of employment or those related to safeguarding the employer from loss or liability. So the processing related to employees and for the purpose of employment shall be under certain legitimate uses. For matters concerning public interest, that is medical emergency, judicial use, etc., by the state and any of its instrumentalities for any functions under any law for the time being force in India. Now, it is very important to bring this out on the elementary level that the certain legitimate uses does not absolve a fiduciary from the obligations. It just exempts the fiduciary from obtaining a consent to undertake the processing. So, certain legitimate uses, you need not seek a consent, but the processing can be done under a lawful basis. Now, when we talk about the legitimate uses, X, an individual makes a purchase at Y, a pharmacy. She voluntarily provides Y her personal data and requests Y to acknowledge receipt of the payment made for the purchase by sending a message to her mobile. Y may process the personal data of X for the purpose of sending the receipt. X, an individual, electronically messages a real estate broker requesting Y to help identify a suitably rented accommodation for her and share her personal data for this purpose. Y may process her personal data to identify and intimate to her the details of the accommodations available on the rent. Subsequently, X informs that Y that X no longer needs help from Y. Y shall cease to process the personal data of X. So, if you see the second illustration, the aspect of providing a consent and even the withdrawal of the consent is being signified under this illustration. Now, one of the most important provisions of the Act, what are the obligations of a data fiduciary? Because by now, I guess everybody would have understood, and by now everyone would be clear as to that the big boss of the data processing ecosystem will be the fiduciary, because they are essentially the ones who are deciding the purpose and the scope. They are collecting the data, they're storing the data, and essentially all the responsibilities for compliance lie on them. So when we talk about the obligations of a data fiduciary shall implement technical and organizational measures to ensure data security and effective adherence with the Act. So, when we talk about the technical and organizational measures, the Act allows a sense and a relief of self regulation for the entities in the ecosystem. So, industry standard technical and organizational measures should be implemented. Such measures could include ISO or SOC 2 certifications, reporting personal data breaches to the Data Protection Board of India and the affected data principals, abstain from processing personal data that may cause harm to children, or undertake behavioral monitoring of children or targeted advertisements, provide a clear, concise, and comprehensible notice to the data principals, protect personal data in the possession and on in the possession of the data processors as well, delete and cause the data processors to erase the data as soon as the purpose is fulfilled and accomplished, engage with data processors to process personal data on its behalf only under a valid contract, as going back to one of the major obligations discussed earlier as well, obtaining verifiable parental consent before processing the personal data of children. Now, it is very important to understand here that these obligations are something which have to be fulfilled at the technical as well as the organizational level by a fiduciary, and non-compliance with either of any one of these obligations will lead or will amount to penalties under the law. Now, we see that a lot of players, a lot of entities in the present processing ecosystem have a huge user base, are processing high quantums of personal data, which may have massive ramifications on the individuals. So the Act essentially classifies between the two entities as data fiduciaries and the others as significant data fiduciaries. So significant data fiduciaries will be fiduciaries again when notified by the central government as entities who are processing vast volumes of data, and the following factors will be the tests or the evaluating factors to classify an entity as a fiduciary or as a significant data fiduciary. So the volume and the sensitivity of personal data processed, the risk slash threats to the rights of the data principal, potential impact to the sovereignty and the integrity of India, potential risks to electoral democracy, national security and interest of the state, and impact on public order. Now, it is unknown and not very clear as yet as to what kind of entities will be classified as significant data fiduciaries. But for starters, it is safe to assume that the financial the entities or the financial institutions will come under the purview of significant data fiduciaries and could also involve some big techs. However, the clarity to this regard will come into light once the rules are notified and implemented. So, in regard to the obligations, what we discussed for a data fiduciary, these are the additional obligations for any entity which shall be classified as a significant data fiduciary. And the additional obligations will include appointment of a data protection officer, appointing an independent data auditor, undertaking periodic data audits and risk assessments, and undertaking data protection impact assessments. Now, data protection impact assessments are essentially assessments which are undertaken when the processing when the scope of processing changes and may pose a risk or a threat to the rights and liberties of the data subject. So that is where the data protection impact assessment comes into place. However, the Act, as the Act talks about the scope of compliance in form of obligations by the SDFs, the threshold for classification and such segregation of the SDFs is yet to be notified by the government. Now, let's move on to what kind of exemptions exist for the processing of personal data. So, whenever you are processing personal data for any of these reasons, you will be exempted from the purview or the scope of the act. Now, this will be for enforcing any legal right or claim. The processing is ordered by any court or tribunal. The processing is in interest of prevention, detection, investigation, or prosecution of offense or contravention of any other law. Processing is of personal data of data principles not within the country but pursuant to a contract outside India. Processing is necessary in the context of mergers or amalgamations or any form of corporate restructuring undertaken. Processing is for the purpose of ascertaining financial information of assets and liabilities of the defaulters, processing for the state instrumentalities, and processing when undertaken for which is necessary for the research, archiving, or statistical purposes. Now, one of the most important aspect of the act: what are the rights of a data principal? It is very important as a data principal and even as a data fiduciary to be very aware and very mindful of the rights which are there. So, rights of a data principal, there are basically four rights which are being provided under the Act. So, the right to access information about processing of personal data. So, every data principal has the right to approach the data fiduciary and seek a summary of how, what, and why. So, how is the data being processed? What data is being processed, and why is it being processed? Along with whom such data is being shared. So, a right to access information will allow you to know essentially what data has been collected from you, why it has been collected, for what corresponding processing purpose it has been collected, and also to which data processor it has been shared with to undertake the processing. The second is your right to correction and erasure of personal data. So the personal data which you provided to a data fiduciary, you have the right to correct personal data which is inaccurate or inconsistent, and even erase personal data if it becomes outdated. So you always have the option of reaching out to a data fiduciary and ask them to correct your data or erase your personal data. Third is the right of grievance redressal, which is one of the most important rights under the law, which allows a data principal to approach a data fiduciary for grievance redressals for all or any forms of issues coming out of the processing undertaken by such fiduciary, or in regard to the non-fulfillment of any obligations by the data fiduciary. Now, it is important that all these rights have to be provided by the significant data fiduciaries as well. Lastly, coming to the right to nominate. So, right to nominate allows a data principal to nominate another individual to act on behalf of the data principal upon the instance of death or incapacity of the data principal. So, every person can nominate another person to act on their behalf in case of death or incapacity in regard to the processing or handling of their personal data. Now we have talked about the rights of a data principal. In law, it is very important to understand that every right has a corresponding duty attached to it. So, for the four rights which have been given to you or given to the data principal under the Act, comes with the following duties. So, the duties are to comply with the provisions of all applicable laws, to ensure not to impersonate another person while providing personal data, to ensure not to suppress any material information while providing personal data for any proof of address issued by the state or any of its instrumentalities, to ensure not to register a false or frivolous grievance or complaint with the data fiduciary, to furnish only such information as is verifiably authentic while exercising the right to correction or erasure. In form of any non-compliance by the data principal, the board may impose a penalty which may amount up to 10,000 rupees. Now, one important aspect associated with data is the retention of personal data or storage of personal data. So, a data fiduciary must erase and cause its data processors to erase the personal data, either if you, as a data principal, put up a request for withdrawal of consent, or as soon as the purpose of processing has been fulfilled and is no longer available. Either of the two, whichever is early, the fiduciary will have to delete your personal data unless such retention is necessary for compliance with any other law which is in force or in effect. One important aspect coming out of the act and associated with the act is the personal data breach. So, any unauthorized processing of personal data or accidental disclosure, acquisition, sharing, use, alteration, destruction, or loss of access to personal data that compromises the confidentiality, integrity, or availability of personal data. So, it is important to note that the aspects of accidental disclosure, acquisition, sharing, use, alteration, destruction in isolation and in combination will amount to personal data. So even if as a data fiduciary you accidentally share it with an entity by mistake, it will amount to personal data. Accidental disclosure will amount to personal data. Hence, it is very important for fiduciaries to be mindful and to be in line with the obligations given under the Act. Accidental disclosures that lead to personal data breach is also covered. Huge responsibility for implementing systems to prevent accidental disclosure. No exceptions will be given even if a person is a victim of a cyber attack or a hack. So please be very careful and be mindful that any form of misuse or missharing, alteration, or destruction of personal data will amount to personal data breach because the quantum of penalties for such data breaches is very high. Now, coming onto the scope of the regulatory authority under the Act, which is the Data Protection Board of India. The Data Protection Board will be the secondary level of grievance redressal after the data principal has approached the data fiduciary and is still unsatisfied of the responses or the grievance redressal undertaken by the fiduciary. Hence, a data principal may file a complaint with the Data Protection Board after exhausting all remedies with the data fiduciary. The Data Protection Board, after receiving a complaint, intimation, reference, direction, can conduct an inquiry with the powers similar to that of a civil court. After investigation, the Data Protection Board can impose penalties based on severity of the breach by the data fiduciary. And if the Data Protection Board thinks that a complaint can be settled through mediation, it can instruct the parties involved to try resolving the issue with mutually agreed mediator or the other Indian, or in accordance with other Indian laws, other Indian ADR laws, as it would be more specific, as the Indian Mediation Act to 2023 and the Code of Civil Procedures Amendment from the 1999. The appellate mechanism, which is the tertiary or the third level mechanism for grievance redressal, has been empowered to the Telecom Dispute Settlement and Appellate Tribunal, that is the TDSAT. So all appeals shall be filed within 60 days from getting a response or a resolved grievance resolved from the Data Protection Board of India. The TDSAT shall conduct hearing where all parties can present their case, resolve disputes within 6 months, and if not, then provide a written justification. The same shall not affect the provisions of the Telecom Regulatory Authority of India Act, that's the TRI Act. The any order passed by the TDSAT shall be executable as a decree of a civil court, and it shall communicate its decision to the Data Protection Board and the parties involved in the appeal. Now, coming to the major issue of non-compliance under the act, which will amount to penalties. So here we are showcasing the high quantum of penalties under the DPDPA. So the first is failure to take reasonable security safeguards to prevent personal data breach may extend to 250 CRs. So it is important to point out here that the upper cap is 250 CRs, and the aspect that personal data breach has occurred will not amount to a penalty, but the failure to deploy reasonable security safeguards, which leads to a personal data breach, will amount to non-compliance and then impose the penalties. Failure to notify the Data Protection Board and the affected data principal in case of data breach, and non-fulfillment of additional relations for personal processing of personal data related to children. Such penalties may amount to up to rupees 200 crores. Non-fulfillment of obligations of SDFs may amount to a penalty of up to rupees 150 crores. Any breach of any other provision of the act may amount to a penalty of 50 crores. And the Data Protection Board determines the monetary penalties considering the following aspects. That is, number one, dependent on the nature, gravity, duration of the breach, and the repetitive nature, sensitivity, and the type of data affected, and if there is any form of gain or loss incurred by the data fiduciary slash the data processor involved in such an attack. Now, as we've just completely covered the aspects of DPDPA, this slide just puts a basic outlook of the global data protection laws. So, if you see globally, almost 70% nations now have data protection laws in shape in one form or the other. So you could see the famous and the most prevalent laws like the GDPR, the CCPA, the Data Privacy Act of 2012 of Singapore, the Privacy Act of 1988 of Australia, the LGPD, the PDP, and such prevalent all across the globe. It is important to point out that these laws are driven by the principles of data protection, which are essentially signified and reflected in all of the data protection laws across the globe in one form or the other. So, this was all about the legal perspective in regard to the Data Protection Act. I would be very happy to take any queries or questions if there are any. Akansha, am I audible?
Yes, sir. So there are some questions in the chat box.
All right. So I will just.
Thank you so for such an informative session. It's now time for a Q&A part, and I would request to the participants to please drop your questions in the chat box.
Okay, so let's start with this. Please, what we have a question from Neha. What do I do if my Gmail ID and phone number is leaked in the dark web? Uh, okay, Neha, that's a very important, that's a very interesting and an important question. So, there is a new feature, there is a new functionality which is now available on Google One, which is actually the aspect which allows anybody to report or check if their data has been breached or if it has been circulated on the dark web. So I would request not only Neha but everyone else, in fact, also to uh, you know go on to Google One today, log in with your Google credentials, and just do a darknet search. So that will allow you to check if there are any, if your data has been breached or by any of the, or is it being prevalent on the dark web or not. If someone uses your name for any fraudulent activities, can this 250 crore penalty be applicable for it? So I think we have this question from Shreya Pal. So Shreya, if someone uses your name for any fraudulent activity, it will not be considered under the purview of the DPDPA. That is more under the purview of the Information Technology Act, and essentially this is something which is similar to phishing. So in that regard, it is important and critical to consider that the applicable provisions will be from the Information Technology Act and not from the DPDPA. So, and also to clarify, the Information Technology Act is the primary legislation which governs data protection in India. The cyber security in India, and one facet of data protection is being covered under the DPDPA. Okay, so I am seeing a lot of questions here. I think if somebody has a mic open. Could they please ensure there's a little bit of disturbance coming? Yeah. So I see a lot of questions coming our way as to how is senior citizens' data is safe in terms of new technology, or if your data is breached by a Wi-Fi provider, how to undertake that. So let me just go back to the basics of the act and the important facets of the act. As a data principle, it is very important for you to be mindful of what kind of personal data you're putting across and what kind of information you're sharing ahead with the Wi-Fi provider, or even for that fact, the service provider. So the aspects related to your consent, to the notice, and your rights should always be taken into consideration while providing your data for to any fiduciary or even for any form of processing. There is no denial that data breaches are inevitable. Data breaches will take place. But if a data principal is mindful of their consent, of their rights, and of their duties, then I personally feel that we can actually negate and minimize uh, the aspects related to personal data breaches quite a lot. Then I have a question, sir. Can you please suggest some apps or websites by using which we can protect our data? There is no specific app or no specific website, Miss Shreya, which can protect your data, but you being responsible and aware about your data will go in a long way. So, one very simple thing is I would always recommend everybody, please go and read your privacy policy of Meta or any of the social media platforms you use today to understand how your data is circulated or shared in the industry. Then Ms. Riya Yadav is asking, is there any kind of risk for using same password for personal aspects like on social media logs or any unauthorized activities? Ms. Riya, I would always recommend to firstly not use the same password. Even if you're using the same password, please make sure that you update it every 2 months and keep the passwords which are very complex in nature. So it could be a combination of your favorite food or your favorite cuisine along with the favorite movie. It could be a combination of your oldest friend last name along with your favorite car. So something of that sort. So in I don't know if everybody is very well aware of this, but I'm sure people have heard about this television series called Jamtara, uh, which is essentially focused on aspects related to fishing. Can I get a raise of hands just to know if people are aware of Jamtara or not? Perfect. When I asked if you read the privacy policy, only three hands came up. Everybody has seen Jamtara. Very good. So the tagline in Jamtara says, "सबका number आएगा," right? सबका number इसीलिए आएगा because if you're not aware or if you're not mindful of how your data is being used or misused, that is how you fall into the prey of a cyber criminal or for any of these elaborate cyber scams now. So please be very cautious of what personal data you're giving out, why you're giving it out, with whom it is being shared, and for what duration the processing has been undertaken. If you're mindful of all these things, I don't see any issue in providing your data, because it is now a way of life. We cannot really live without the functionalities provided by the internet and various applications in present time. So I hope I was able and helpful to answer the queries. To Okay, I think there's another last question. I think, yeah, to what extent does two-step verification keep a profile safe on social media? Uh, to a very large extent, it does keep your profile safe on social media. As a best practice, I would recommend everybody to go back home and deploy two-factor authentication on your WhatsApp, on your social media, and even on your banking applications, because it allows you to be aware if there is any unauthorized access or if there's unauthorized login to your platform in that regard. And despite of being in the professional, in the legal field with the tech law, I have myself been a victim of instances where somebody is trying to gain access to my Facebook account or my Twitter account. But with two-factor authentication, yes, it is very easy for you to avoid this and even ensure that the other person does not get any unauthorized access to your account. So yes, two-factor authentication is a very important thing. Regularly, please update your passwords. Do not use APK or crack versions of applications or web pages on your devices. Regularly scan your phone for any irregular activities. And most importantly, report. This is one of the biggest issues which we're facing in today's time. I'm so sorry, Akansha, I'm just taking a little bit of more time. But this is something which I feel is very important, critical to address in present time. We are all seeing and reading a lot about digital arrest, which is essentially people being arrested at their own home or at a hotel or at any confined location for a long, prolonged period of time, and they're being paid to pay money to the criminals. In fact, last week I read the news where a 80-year-old woman was duped of 20 crore rupees over a span of 6 months in digital arrest. So see, no scammer is smarter than you. No scammer is more intelligent than you or is more aware of you. These people are just using simple social engineering tactics and simple social engineering skills to lure you in. It is just that be mindful. आज से पहले कभी किसी पुलिस वाले या फिर किसी लॉ इन्फोर्समेंट एजेंसी के ऑफिसर का आपके पास फोन कभी नहीं आया होगा. इनफैक्ट ऑन द कॉन्ट्ररी आप किसी से उनकी बात करा रहे होगे अगर आपको कहीं पकड़ा गया तो यू विल नेवर गेट अ कॉल फ्रॉम देम. सो अगर आपके पास कोई कॉल आ रहा है डिजिटल मीडियम पे आ रहा है उस पर इतना आसानी से ट्रस्ट ना करें. Please be very mindful of your basic cyber hygiene protocols, and then I don't see that if you being mindful of all these things your data can be misused. So I hope I was able to address a little bit of such queries in regard to cybersecurity and data protection. Do we have any other queries or anything else?
Thank you, sir, for such an enlightening session. Your insights into were truly eye-opening. This brings us to the end of today's webinar. A heartfelt thank you to our esteemed speaker, Advocate Abhishek Singh sir, for sharing his expertise and helping us understanding data protection laws, a legal perspective. I'd also like to thank all the participants on behalf of Project CyberShield for being a part of today's session. Your involvement has been integral to the success of this webinar. A gentle reminder to all of the participants that it is mandatory to fill out the feedback form. Before we conclude, I'd like to remind you about the next session scheduled on 7th April 2025. We will be discussing jurisdictional challenges in cybercrime prosecution, a crucial topic that everyone should be aware of. The session will begin at 6 p.m., and we encourage you to register to expand and enhance your understanding of cybercrime and become more cyber aware. Remember, awareness and vigilance are our stronger defense against cybercrimes and threats in today's world. Stay connected with Naksh Foundation and Project CyberShield for more initiatives like this. Have a wonderful evening and stay safe online. Thank you. Thank you so
Thank you,
much.
ma'am.
Thank you so much for the opportunity. Good evening, everyone. Thank you.
Thank you so much, sir. All the participants are requested to please fill the feedback form. It is posted in the chat box.
Definitely, sir. Can I ask you a query?
Yes, please go ahead.
Okay, sir. I'm from Bangladesh. I'm from Chile University Law Department. But session, I have a query to you that uh, by the integration of the AI technology, there are some misuse of social sites, basically the Instagram, YouTube, WhatsApp, and some of the times in Facebook also. So as a law student, how can we protect the future complainants by the people, by the common people? And with the law students, we can know that we can take the legal actions, but it is not possible for the common people. How they can
Fazul,
engage the
your
law?
voice is not clear. If it possible, can you write this question in chat box?
Okay, sir, definitely.
Okay. Yes, please go ahead.
Uh, Faisal, based on what I could gather on what you just asked, let me just clarify one thing to you. A legal protection can be given to you for something which is legally recognized. I cannot protect you, or the law cannot protect you for something which has not been recognized under the law as yet. And when we come on to the aspect associated with AI technologies or AI platforms, again, going back to the basics and the principles, like we all are using Chat GPT, but has any one of us read the terms of use of Chat GPT or the contractual obligation you enter into with Chat GPT or any of the other AI platforms? So again, yes, one way to protect yourself is being aware and being a responsible user. And secondly, as and when the regulations for the AI specific regulations come into picture, the rights and duties of the AI users will be magnified. And for that regard, as law students, I would suggest as one of the best practices as law students would be to actually ensure that your daily activities, even when you're using an AI powered tool for creating a college submission or anything, are within the constraints of the legal permissibility. So, in that regard, it will not only include your cybersecurity or data protection, but will also include aspects related to intellectual property. So, a responsible user, along with an aware user, will is the way to keep yourself safe in the AI times to come. That's what I have to say for that.
Thank you, sir. Thank you, sir, for your feedback. But I got you properly. But sir, there are some new initiative that can happen by the AI technology. We can see it in different form. By the There are a verdict by Allahabad High Court that they interpret the AI technology by the man-made technology also. So man also input his brain by the AI technology. So initially it can be arisen by the man, and they malafidly use the AI technology. So in some cases, can we victimized the people by AI technology?
Not essentially, Faisal. I would not agree onto that entirely because again, AI is still a medium. AI technology, even if you talk about it in terms of a deep fake or something of that nature, it is again a mode for a bad actor or for a cyber criminal to lure you into their traps. So even if it is an AI powered tool which is being used, again going back to the fundamentals, if you are actively reporting it, suppose if you come across a message or a, let's say, a call in which you know that this call is AI generated or is meant to harm me, it is important for you to report it. If you don't report it, then the perpetrator goes free. Similarly, if you go onto Instagram or to any of the social media platforms, wherein you know sometimes now we have the capability to see a post or a picture and realize if it is a AI generated picture or if it's a real image. And if you see that it's an AI generated image which may cause a confusion or which may not be in alignment with the legal permissibility, we should report it. And also coming on to the aspect of regulating AI, let me just put it in this in a very elementary way in as we say in the policy sphere. Technology will always be half a step ahead of law. That is the nature of it. That is how it is. But at the same time, having said that, the Ministry of Information Technology is working on an AI subcommittee, which is yet to deliver its first submissions by the month of July. And the government and the ministry is very proactive in regulating AI right now. So it might not be the case in the present scenario, but things are changing for the good and will be good in the times to come. So this query would, I guess, this question of yours would partly be answered in 6 months and will be answered as a whole in maybe a year or in or 1.5 year as the applicable laws are notified. I hope that was helpful, Fajul.
Thank you, sir. Thank you. Thank you so much.
Hello, hello.
Yes, Miss Neha.
गुड इवनिंग सर। सर मेरे दो क्वेश्चंस हैं। एक तो मेरी जीमेल आईडी जो है वो डार्क वेब पर ऑलरेडी लीक्ड है, जीमेल आईडी और फ़ोन नंबर। और दूसरा मेरा क्वेश्चन है कि अनियन साइट्स और प्राइवेट डीएनएस के बारे में मुझे थोड़ी इन्फॉर्मेशन चाहिए।
Ma'am, I am a lawyer. I'm not a technical expert. I'm so sorry. So I would suggest कि जो onion sites and DNS sites के बारे में आप जानना चाहते हैं, I would suggest कि आप relevant experts से internet पे किसी ने कोई article या फिर कुछ अच्छे से समझाते हुए लिखा होगा, आप उसको पढ़ें, because हो सकता है मेरी इस मामले में knowledge is
ओके
not that accurate. बट अगर आपका डार्क वेब पे जो आप बता रहे हैं कि आपके क्रेडेंशियल्स प्रिवेलेंट हैं, सो सबसे पहले तो आप गूगल वन पे एक बार डार्कनेट सर्च करिए। गूगल आपको एक ऑप्शन देता है वहां पे रिपोर्टिंग का भी, तो आप वो उसको
ओके
गूगल के थ्रू भी रिपोर्ट कर सकते हैं।
ओके
एंड सिंस अगर आपको ऐसा लगता है कि आपका ये ईमेल आईडी और आपका फोन नंबर वहां पे लीक्ड है, तो आई वुड रेकमेंड कि ग्रेजुअली आप एक नया ईमेल आईडी बना लीजिए और एक दूसरे नंबर पे पोर्ट कर दीजिए, जिससे आगे जाके कोई आपके ऊपर एप्लीकेशंस ना
ओके। तो गूगल वन वन पर
जी, गूगल वन पे आप जाएँगे, सो देयर इज़ एन ऑप्शन कॉल्ड डार्क वेब सर्च करके एक वहाँ पे ऑप्शन है। तो आप उस पे
यस।
क्लिक करेंगे तो वो आपको आपका पूरा गूगल का डेटा और जो भी आपका है वो सब कुछ आपको बता देगा।
ओके सर, थैंक यू।
Can I asking you something, Abhishek sir?
प्लीज़ प्रवेश गो अहेड।
Yeah, actually I have someone's questions, cybercrimes codings. Nah. Actually recently I listening your someone's casings according financial fraud according. तो बेसिकली मैं अहमदाबाद सिटी से हूँ और साइबर सिक्योरिटी में अभी मेरा CES मास्टर्स इसी काउंसिल से चल रहा है और अभी NFSU गांधीनगर यूनिवर्सिटी है, इसमें मेरा स्टडी चल रहा है अभी डिजिटल फॉरेंसिक्स के अकॉर्डिंग। तो मुझे क्वेश्चंस मेरा क्वेरी ये है कि जैसे कि लाइक कोई स्कैमर्स है, राइट, और अहमदाबाद या गुजरात कोई कोई भी सिटीज़ के अंदर कोई भी सिविलियन सर्वेंट है, उसके बैंक अकाउंट्स में वो मनी ट्रांसफर्स कर देता है, राइट्स,
हुँ,
और जिसका अकाउंट्स में से पैसा ट्रांसफ़र मनी ट्रांसफ़र हुआ है तो गवर्नमेंट में वो फर्स्ट पार्टी कंप्लेंट्स करती है साइबर क्राइम के अंदर। तो साइबर क्राइम पुलिस डिपार्टमेंट्स अकाउंट फ्रीज कर देते, तो जिसके अकाउंट्स में से पैसे सेकंड पार्टी के अकाउंट्स में गए हैं उसका अकाउंट फ्रीज हो चुका है, राइट। और
राइट।
जो सेकंड पार्टी है वो फिर बैंक में जाती है, पुलिस थाने में जाती है, तो वहाँ पे वो लोग बोलते हैं कि आपको जिस थाने से फ्रीज किया गया अकाउंट्स ना उधर जाना पड़ेगा। तो अभी फिलहाल ये केस में हम इसको कैसे रिजॉल्व कर सकते हैं?
देखो इसमें ज़्यादातर ये वाली जो एक्टिविटीज़, ये जो ट्रांज़ैक्शंस
ये
होती हैं।
अहमदाबाद गुजरात के अंदर करीबन अहमदाबाद के गुजरात के अंदर मल्टीपल्स जो सिटीज़ हैं ना, जैसे कि जामनगर हो गया, सूरत हो गया, बड़ौदा हो गया, अहमदाबाद, उसमें लॉट ऑफ ऐसी कंप्लेंट्स आती रहती है बहुत सारी हर रोज।
राइट। बट सी इसमें इसको अगर इफ आई एम बीइंग ब्रूटली ऑनेस्ट ऑन दिस, इसको हम इतना ब्लैक एंड व्हाइट में नहीं देख सकते।
ओके।
पहली बात तो जो वो ट्रांजैक्शन की गई है, जो कि
हम्म
फ्रॉडुलेंट ट्रांजैक्शन थी,
हम्म
वो ट्रांजैक्शन की ही क्यों गई थी? एज अ सिविल सर्वेंट और एज अ गवर्नमेंट एम्प्लॉय, हमें या फिर किसी भी गवर्नमेंट एम्प्लॉय को इस मामले में थोड़ा-सा अवेयर होना पड़ेगा कि आप किसी को भी किसी भी क्यूआर कोड पे पेमेंट नहीं कर सकते, नंबर 1।
हम्म
नंबर 2, जब आपकी कोई भी ट्रांजैक्शन या फिर आपका बैंक अकाउंट किसी सस्पेक्टेड ट्रांजैक्शन के तहत ब्लॉक किया जाता है, वो ब्लॉकिंग बैंक से इनिशिएट होती है, जिसका मतलब है कि बैंक ने आपकी उस ट्रांजैक्शन को सस्पिशियस बताया है।
हम्म
सो अगेन, अगर आप नहीं रिपोर्ट करेंगे तो बैंक करेगा, और अगर बैंक रिपोर्ट करेगा तो उनका जो प्रोसीजर है वो फॉलो होगा। तो इस मामले में जब हम कोई गलत ट्रांजैक्शन हो जाती है या फिर कुछ हमें दिखता है कि कुछ फ्रॉडुलेंट हो गया है, अगर आप खुद ही उसको उसी समय रिपोर्ट कर देंगे, तो
हम्म।
आपकी सिर्फ एक वो पर्टिकुलर ट्रांजैक्शन है जो होल्ड करी जाएगी और हो सकता है 48 आवर्स के अंदर अंदर वापस भी आ जाए।
और दूसरी ये बात है, उसमें लेयर्स आते हैं, लेयर 1 है, लेयर 2 है, तो
So
उसके
sorry to
अकॉर्डिंग मुझे
interrupt.
गाइड्स कर
We
सकते
have
हो क्या?
a So we have a time constraint. So can you please like direct your question through mail?
Sure. So I think that works.
Yeah. So all right. So thank you so much, sir, for such an informative session. I'm sure that we all learned a lot from you. And if anybody has any further questions, please write it in the mail, and sir will answer that there. Thank you so much again. You all can leave now.
Thank you so much, Abhishek sir.
Thank you, everyone. Thank you, Kansha. Thank you, Simran. Thank you, guys.